This is Group 3, Project 4,
Expert Testimony Presentation. Hello all. I am Digital Forensics Investigator Joseph Montgomery, representing Group 3, here to present expert testimony. Our investigation throughout all three projects found a single theme. Each project taught students how to create a secure network within the public and private sector. From the analysis performed at exercises, we investigated how to create strong controls against intrusions and cyber attacks. These controls comprised of detection software, physical controls, relevant policies designed to address current threats to organizations, and an adaptation of an incident response plan that can address the variety of challenges in cyber attacks. We learned that while policies across the Five Eye Partnership differ, best practices should be developed through the deployment of intrusion detection and monitoring software. Hardening existing systems through physical and virtual measures, educating personnel on best practices, and sharing information with key stakeholders in all phases of cybersecurity.
Hello, Digital Forensic Investigator Montgomery. I am Belinda Frazier, a representative of the moot court. I'll be asking questions in regards to your team's information and data collection for the FVEY project. What are the legal challenges associated with cyber incidents involving foreign countries? How do internal laws affect e-discovery? Please reference and discuss all international laws that may influence a forensic investigation in the country that your team is assigned.
Thank you for that question, Ms. Frazier. I would like to respond in three parts. Part A. A key challenge in dealing with cybercrime is that the internet has enabled cybercriminals in one country to attack computer systems in foreign countries. There still lacks good laws and regulations on dealing with international crime. The rivalry between nations play a role in hindering the enactment of better laws to regulate international cybercrime. Some governments have failed to agree on the extradition of cybercriminals operating in their territory to face charges in the foreign countries whose systems they attack. There have also been allegations of some states sponsoring cybercriminals to attack other countries with the goal of stealing sensitive information, disrupting the country's information technology infrastructure, among other reasons. Answer B. One law I can name that affects e-discovery is the Fourth Amendment of the United States Constitution, with other privacy laws in regard to the collection of electronic evidence. The laws require the issuing of a warrant before the seizure and possession of electronic evidence. Such information is critical to securing the evidence because if there is an attempted or successful attack, electronic evidence cannot be collected or issued to law enforcement agents without a proper warrant. To answer Part C, some examples of international laws that influence forensic investigations are New York State telecommunications security policies, New York State telecommunications web and digital government policies, New York State telecommunication policies, New York State telecommunications IT standard policies, New York State telecommunications technology development use policies. All of these policies and laws affect the search and seizure and collection of possible digital evidence in an investigation.
What are the legal challenges of accessing and retrieving electronic evidence stored on foreign soil? Assuming cloud storage was used, what procedures were followed to access and retrieve digital evidence stored in the cloud?
Yes, there are legal challenges of accessing and retrieving electronic evidence. One major legal challenge is cloud computing. Cloud computing has created new and complex challenges for regulators, investigators, and organizations. Cloud services can store data in data sources located in a country of their choice. However, the cybercrime laws in the country where data is stored may differ from laws in states where customers are situated. If an attack occurs to one or more customers of the cloud service, it is usually very challenging to investigate the attacks and prosecute the criminals involved in the attacks. During our project, we developed Cloud storage investigation procedures. The process of the collection of evidence included identification, preservation, collection, examination, analysis, presentation, and a final decision.
Specific to the country that your team was assigned, how did the international laws and jurisdictions influence the processes and procedures followed during the forensic investigation?
Our team was assigned to the country Canada. Canada is a part of the United Nations and influenced by UN international laws. To be more specific, the UN has helped in the creation and adoption of the international laws and regulations that govern information security. Different UN bodies push for the enactment of international laws that impact their core functions: the unauthorized acquisition, analysis, transfer, and preservation of individuals, governments, non-governmental organizations. Information is contrary to international law and affects Canadian forensic investigations. An example of jurisdictional law that could influence forensic investigation is the aforementioned Fourth Amendment in the U.S. It currently requires a proper warrant of the search and seizure of evidence from a citizen. This is an example of international law that influences the processes and procedures during a forensic investigation in Canada.
What conflicts arose between ethics and international laws during the forensic investigations? How did these conflicts affect the investigations? And how were the conflicts mitigated or resolved? Investigator Montgomery, one last question. What steps were taken to protect United States soil and citizens during the international investigation? Please describe any risks to the country, businesses, or citizens from your investigation.
To help protect the citizens of the U.S., we created a National Infrastructure Protection Plan and a risk management framework. Protecting and providing for the continuity of critical infrastructure and key resources of the U.S. is essential to our national security, economic strength, and public well-being. Because the U.S. has an open and technically complex culture that consists of critical infrastructure that is owned and operated by the public sector, adherence to the policy set forth by the National Infrastructure Protection Plan is strongly recommended for private companies supporting government infrastructures. Laws that specify the punishment for engaging in cyber crimes have been updated. The strict cybersecurity policies significantly impact on research and development of better cybersecurity tools. Organizations are required to continuously enhance the security of their systems to protect sensitive information. Failure to act accordingly will expose the country to embarrassing and costly cyber attacks. Now, next, let me discuss risk. A risk is a potential for loss, damage, or destruction of an asset as a result of a threat exploiting a vulnerability. Some risks we have found during our investigation are SQL injections, buffer overflow, arbitrary code executions, and privilege escalation. Our recommended mitigations can help defend against the listed risk. Ms. Frazier, thank you for your questioning and your time. To conclude, Group 3 believes collaboration between member nations can form the basis of innovative countermeasures against cyber attacks. However, additional work is needed. While the United States, Canada, and the United Kingdom have established best practices and measured guards, Australia and New Zealand have adapted reactive measures with little to no control measures in place. A unified approach towards establishing stronger policies and legislations can only benefit the Five Eye Alliance members and protect critical infrastructures. I want to thank the court for listening to our information and results. Ms. Frazier, you are correct. Conflict can derive between ethics and international law. One conflict of ethics and international law is the allegations of some states sponsoring cybercriminals to attack other countries with the goal of stealing sensitive information and disrupting the country's information technology infrastructure. Some governments have failed to agree on the extradition of cybercriminals operating in their territory to face charges in the foreign countries whose systems they attacked. It is unethical for a country to refuse extradition of a cybercriminal that has caused harm and possible financial loss to a foreign nation. It is also against international law for a foreign nation to collect digital evidence without following jurisdictional regulations. The clash of these stances creates many events of conflict. The effects of this conflict can prolong an investigation, which forces negotiations to take place in order for prosecution to be completed. To mitigate the conflict, foreign nations must procure warrants and begin negotiations to rebuild relationships and find common ground to have extradition and prosecution.